May it please the court, my name is Ruby Clarke and I appear for the defendant Darren Selders. We submit to the court that Your Honour exercised judicial discretion under section 130 of the Evidence Act to exclude two pieces of admissible evidence. The defendant's admissions in the police car on the 20th of March 2019 and the defendant's confession in the police station later on the same day. Our first submission is that the defendant's admissions be excluded under the fairness discretion. In Hasler, Justice Thomas determined exclusion should only occur when the evidence is of relatively low probative value and its prejudicial effect would be substantial. The admissions by the defendant were not recorded by the police officers, and as such, this lowers its probative value. However, the prejudicial effect of the statements would still be significant. Furthermore, the statements were an act of gratuitous concurrence, as the defendant is a young Indigenous child who was frightened by the police officers as figures of authority, and as such, he agreed with their questions in an attempt to avoid further conflict. Therefore, the admissions are an insubstantial value, yet they are highly prejudicial, as the evidence would weigh more heavily in the jury's mind than it should. If Your Honour is not satisfied, we alternatively submit the evidence be excluded under the Public Policy Discretion due to the breaches of the Police Powers Responsibilities Act. As the defendant is an Indigenous child, police breached sections 420 and 421 by questioning him without notifying a legal aid organisation and failing to allow him to speak to a support person. Sections 418 and 431 were also breached by failing to inform the defendant that he may communicate with a friend, relative or lawyer, and failing to caution him of his right to silence. As the police officers initiated the questions which resulted in the defendant's admissions, it is reasonably practicable for them to record the questioning process. Their failure to do so is a breach of section 436. As you can see, Your Honour, there have been numerous breaches of the PPRA provisions. In Bunning and Cross, Justices Stephen and Atkin developed a multifactorial test to consider when determining whether to exercise the public policy discretion. The multiple and systemic failures of police officers infer that their conduct was deliberate. Regarding the second factor, even if the Crown argues the evidence is essential to their case, it is of low probative value and was obtained through deliberate breaches of the PPRA, and as such should be excluded. The third factor leans towards exclusion, as it is clear there was no emergency pertaining to the questioning circumstances. While the charges of 8 burglaries are serious, this reason alone should not excuse the officers' improper conduct. The purpose of the PPRA is to prevent misuse of power by police officers, particularly against vulnerable classes like Indigenous children. Therefore, we submit that in weighing up the relevant factors, the evidence be excluded on public policy basis. Your Honour, our second submission is that the defendant's oral confession to 9 burglaries and theft be excluded under the fairness discretion. The evidence is of low probative value, as he confessed in an act of gratuitous concurrence. This is based on the support person telling the defendant to just make sure he answered the police's questions, and he has previously engaged in gratuitous concurrence when responding to police questioning. The confession is highly prejudicial, as the jury are likely to give it more weight than it deserves. Using the language of Hasler, the prejudicial effect outweighs the probative evidence of the confession, and as such, we submit Your Honour exclude it. Alternatively, we propose that Your Honour exclude the defendant's confession under the public policy discretion due to the numerous breaches of the PPRA. Section 421 has been breached, as the defendant had no choice in his support person. As a middle-aged white woman who the defendant had never seen before, it is highly unlikely he would have chosen Wendy, nor is she included in the list of support people at the police station. Furthermore, sections 418, 420, and 431 were respectively breached, as police failed to inform the defendant he could communicate with a friend, relative, or lawyer, nor did they notify a legal aid organisation or caution him of his right to silence. Therefore, the confession was obtained by police acting improperly or illegally. In determining whether to exclude the evidence, the factors in Bunning must be considered. The continued failure by the police to follow procedure indicates their conduct was deliberate. The confession to the burglary and theft that occurred on the 20th of March 2019 is vital to the Crown's case, as there is no other evidence the defendant committed the offence. However, the confession is of low probative value and was obtained through deliberate breaches of the PPRA, hence indicating it should be excluded. The third factor points towards excluding the evidence, as there is nothing to suggest the officer's conduct was a genuine response to pressing circumstances. While the multiple charges of burglary and theft are serious, we submit they are on the lower end of the criminal offences, as the damage is not irreversible. Under the fifth factor, exclusion is likely, as the purpose of the PPRA is to prevent this exact kind of conduct. Therefore, considering the factors in Bunning, the evidence may be excluded under the public policy discretion. Summing up my submissions to the court, we believe that the correct course of action is for Your Honour to exercise your judicial discretion and exclude the two pieces of evidence. Both pieces of evidence are insubstantial and hence may be excluded as they are significantly prejudicial. Alternatively, the public need to bring a conviction against the defendant is likely outweighed by the public interest in the protection of vulnerable children from unfair treatment. If there are no further questions, that ends my submissions, Your Honour.